Okay, so let's start. Hi everyone. Hello, good evening. Thank you for coming. We're gonna have a really interesting topic today, but let me first give you some words about what is AI9. Who knows what is AI9 Startup Campus? Okay, we have interesting four or five people. Okay. So my name is Arik. I'm one of the co-founders of this place called AI9 Startup Campus. And the idea of this place is to support startups to go global. So this is an international startup campus that has a goal to help educationally or with connection to investors or education or mentoring, whatever. We haven't yet opened the whole hub. We have 3 floors. So this is the area that we give for free every day to work from here. So if you look for a place to work from every day from 10 to 6, you can come and work from here. But then we're going to have the 3rd floor for the all acceleration programs. Probably and hopefully from the end of this year, we'll see how the construction goes. But yeah, so we're going to have lots of acceleration programs and educational programs for startups, product management, and some other things, mainly focusing on AI. And today's topic is really interesting one because usually we discuss how to start the startup, how to fundraise, how to, I don't know, find first customers, but we don't really often talk about the legal part. And we have the unique opportunity to discuss it today, which is, I hope, like get and create your questions that we're gonna have discussion after the presentation. I hope we can challenge the legal part and to learn a bit more what we should do or what we shall know before or after starting the company. So please welcome Marta Hovanesian, who is the legal guru in all these fields, AI, GDPR, and I think we have the unique opportunity to learn from you. Stage is yours.
Thank you, Arik. Welcome, everyone. My name is Marta, and I'm a privacy data protection AI lawyer. Dutch qualified mainly EU laws, but I've also worked at an American big law firm for 6 years, and I've worked with a lot of global big tech companies all across the world. So I've seen how like big players handle data protection, and I'm here to help the startup community also think about data protection, know what it's about, what AI laws there are that they need to take into account when they grow. Especially as you like in Armenia itself, the data protection laws aren't that mature, but as you scale and as you grow towards the EU or the US or generally globally, these are going to matter for you. And because this is also part of an LLM Summer School, is going to talk about the LLM regulatory framework specifically. What we'll talk about today, what we'll discuss is GDPR. That's one part. Who is familiar with the GDPR? Okay, familiar. Content knowledge or just familiar? Who have content knowledge? Okay. Okay, good. We'll talk about the EU AI Act, which is the first big AI regulation in the world. And then we'll also look at the Colorado AI Act, just to make a point that the US also has AI regulations. It's not just the EU that's being difficult. Also, in terms of GDPR, there are also US consumer privacy laws that apply, but the framework is very decentralized. It's all state-based. There's no federal privacy law, but there are sectoral privacy laws for health, if financial sector health laws as well. Okay, moving on. So why GDPR? First, it applies to the processing of personal data. So any personal data, whether it's in context of LLM training, LLM output, or having to do with LLM. So GDPR is like an overall framework for all the processing of personal data. And then the GDPR also has specific rules about automated decision making, which takes place with AI. So that's interesting to look at. First, yeah. So where can we see GDPR applicability? It's like very global, non-technical overview of LLM training. But First, GDPR applies when you're thinking about what data to use to train your models. It applies when you're doing the actual training. So first, it's a free selection of the data. It could be any web crawl data, government data, open source data. Just the collection thereof is subject to GDPR. And then we have the training, we have the input, but people can have personal data as part of their input when they submit a query. And then the output could also include personal data, so that's also where GDPR comes. The main thing about GDPR is that it requires a legal basis. EU GDPR doesn't mean you can't collect data, it doesn't mean you can't use data, it just means you have a legal basis. That could be consent, which, many people think we need consent for everything, but it's definitely not the only legal basis that is available. You could also have a legitimate interest to collect data. That requires a balancing of interest between your interest, the neighbor, the interest of the individual to have their privacy and data protection safeguarded. So it's always a balancing. Where it gets tricky with the GDPR, so if you're using health data to train your model or race, political affiliation, things like that are classified as sensitive. That's when you would need consent. There is no other legal basis available unless there is like a legal obligation in EU law that requires the process of information. So that's where it gets tricky. And what often happens is that they filter out certain categories of sensitive data when they collect the information so that there's no consent obligation there. GDPR also requires transparency, so you can transparent about the data that you collect, what you do with that data, how you share it, who you share it with, how long you store it, etc. Broad transparency requirements. It also requires you to think about data protection principles like data minimization, which seems at odds with data training, right? Data as much as possible. But the point is you need to look at like what do you really need, what is qualitative data for the purposes that you're collecting it for. So not just everything, really think about it. And then that goes hand in hand with purpose limitation, security, retention periods, that type of thing. One tricky aspect of GDPR in context of LLM is individuals' rights. Individuals have the right under GDPR to delete their data, access their data, correct their data, etc. How is it, how can they exercise those rights in the training model? Are they able to ensure that their data will not be part of an output, for example? Are they able to delete it from the training data? Are they able to edit the information that's incorrect, especially in relation to outputs like data hallucinations? Those are all challenges that we face when we're thinking about GDPR and LLM parsing. So the GDPR has a specific framework for profiling and automated decision making. If there's an automated decision without human intervention that has negative effect on an individual's rights or legal effects like automatic denial of contract based on automated needs, those are not required in the GDPR. That there's consent, the individual specifically agrees to have that made automatically, or there's a basis in review or member state law. What does automated decision use like? There's no meaningful human involvement. So the fix for that is usually there's a human that looks at credit. Like there's a credit scoring, for example, there always needs to be in the loop of the information, makes the decision without letting the algorithm make the decision for them. And profiling is something we see a lot in the context of marketing, where profiling is done with individuals' data, and on the basis thereof, there could be automated decision making. Interesting to keep in mind is if there is any automated decision making process, you need to inform individuals of the logic that goes with that decision making. It needs to be enough for the individual to understand how the decision was made so that they can contest the decision, how the decision could have been influenced, what parameters were part of the decision. The point is that they need to be able to express their views in relation to the decision that was made, and they need to also be able to understand what happened with that, why they had that negative effect with their data. So far, are there any questions, thoughts, ideas related to what we said? Moving on to the AI laws. So we have the GDPR, but it's not just about personal data. Anything non-personal data is not covered by the GDPR. So we, and especially with OpenAI, release of Tortilla, et cetera, there's been a huge push to have AI regulations in place. This is a map that shows you what jurisdictions have AI regulations or laws. There's also a bunch of them that have draft laws or guidance, or like moving and darker ones. There's the ones that already have laws of regulation. So you can see a pretty big part of the map is already covered. If you go to the source that I included below, you can also see the specifications of which laws those relate to specifically. So what does AI legislation cover? It covers models as well as systems. A model is usually part of an AI system, but there are rules for both. And it applies to, there are different roles that you can have under the AI. You can be a provider of an AI system. You can be a deployer of an AI system. You the person that, the company that uses the AI system. You can be an importer. So if it's a third country's AI system that you are making available on the new market, importer. And there's also the distributors. When other than the provider or the importer that makes the system available and use. There are different roles. Most obligations apply to the provider. Some apply to also the deployers. But you can become a deployer of a high-risk AI system and make substantial modifications to the system that you use, or if you put your name or trademark on it, those requirements automatically apply to you as well. Who's familiar with the AI Act? The new AI Act. Who's looked into it, has an idea. A little bit on that. So the AI Act, like I said, is considered one of the first comprehensive AI regulatory frameworks. It's been part of a very, very, very long negotiation process in the EU. So the European Commission, European Parliament, and the European Council, they need to agree on the language of the law before in the EU. And so they're always part of the negotiation. Some happen pretty quickly, some take a very, very long time, because all the 27 EU member states have their opinions. Some want very strict regulations, others want very open regulations, others want to protect innovation and be tempering innovations. Others are concerned about their national security and they don't want to give any rights to the EU to decide for them. So it's been a very complicated process. I think everyone applauded once they finally had agreement. And now there are huge code of practices. There's also a lot of controversy around the code of practices for gen AI models. So it's been an interesting sort of offer to watch from me in any case. It's entered into force, but not all obligations apply at the same time. So it's a staggered implementation framework. And you can understand the AI Act in the context of product safety regulations like CE marking. Some requirements in the AI Act are pretty similar to, you need to undergo quality assessment, you need to have a CE marking on your product, you need to have robust risk assessment procedures, et cetera, et cetera. So it can be somewhat familiar. Yeah. So the AI Act doesn't apply to all AI. There's a standard approach, and it takes a look at risk associated with that. There's unacceptable risk that means that it's prohibited to use the AI system in the new market. we'll talk about what is prohibited, but social scoring or deceptive techniques to influence someone's decision making against their will, things like that, like it's unethical and not desirable to have, they're prohibited. And there are also high risk systems. They're allowed, but there are high requirements associated with that. Like I said, quality assessment, risk management, data quality, policies, procedures, lots of sort of compliance steps that go into that. And there's limited risk, like chatbots, like there's regulations around chatbots, deepfakes, etc. They're not prohibited, they're not specifically high risk, but there are some rules around you and how you need to use those. And then there's, the risk, minimal or no risk, they're allowed and you don't have to do anything. Their relationship there too. Starting with the prohibited one. So the first one I already talked about, like deceptive techniques with the risk of harm, exploiting vulnerabilities of people, like children or vulnerable people, like financial issues, and making them do something that they actually wouldn't have wanted to do. A social scoring, classification of people based on their behavior and personality, leading to detrimental treatment. So it's always like negative effect that follows that AI practice. Profiling for assessment of personality traits, that's predictive policy and policing relationship too. And then there's a chart that's scraping facial images, like theory AI. Comparing emotions in the workplace and application. So emotion recognition is you need to think about as this real-time remote biometric identification. Anyway, is there anything here where you're thinking about what this shouldn't have been covered? Anything here that you think, oh, it should have been covered, when it's allowed, or something I'm working on, or no discussion, we all think it's pretty good, and rightfully so. Okay, good. It's all very relatable to each other, you mean? You think it's overregulated? Okay. Okay. We can have that discussion. At the workplace. So that, I mean, this is very short, but and for emotions in the workplace and education. It's only real-time remote biometric identification, like tablet camera that scans everyone biometrically that walks by, and then used for law enforcement purposes and. It could, yeah, maybe it happens. Well, if it's really prohibited AI practice, then you just can't operate in the EU, so you have to only offer that practice in China or elsewhere. For the prohibited AI practice, like a no-go area that can have a global, approach to that. If it's a high risk system, you can think about a global approach, but for prohibited one, and if you do have a prohibited AI practice of EU by certified million the annual turnover. So moving on to the high risk. So many AI applications will likely be a high risk AI system rather than prohibited. For the prohibition, it needs to have like really bad negative effect on the high risk ones are also interesting. It applies to the product of AI systems that are already regulated, like medical health devices and other EU regulations that already apply on a product level. They are considered high risk AI systems. And then there's 8 specific application domains that are considered high-risk AI systems. We'll talk about which ones those are, but what you should know for the high-risk AI systems that they have extensive requirements. You each have a retention system, data governance measures, technical documentation as well, record keeping capabilities, logging capabilities, transparency mechanisms, student oversight, et cetera, et cetera. They're all included there. But just to say, policies, procedures, and governance measures that go with it are very, very high and require a lot of thought and preparation. There is a derogation, like an exception for if the intended use really is limited to or narrow procedural tasks, so it's being applied on a narrow basis. Or if it's to make improvements to the result of previously completed human assessment, or to perform mere preparatory tasks. So really here also you can see the human in the loop more is more assistive, but the less likely is to be high-risk AI system. These are the systems that are already regulated, like machinery, toy safety, lift, and so radio equipment. These are high-risk AI because they're already regulated. There's this overlap to the AI Act regulation already applies. What's more interesting to look at is the 8 areas where there's a high-risk AI system designation. Biometrics and biometric-based systems. It doesn't apply to just verifying identity, but other biometric applications are high-risk AI. If it's for the management of critical infrastructure, consider high risk. Education, vocational training to sort of assess the development of the student or their progress. That's done on the basis of AI. It's considered high risk. In the HR field, employees, workers, if you're using AI systems to assess their performance, to assess their competence, to assess their eligibility to promote, that's considered to be high risk. And there are a couple of public sphere, like law enforcement, access to public private services, like credit loans. You can't do that only on the basis of AI. You can do that in high risk AI system. Access to health insurance, other life services, and then migration and administration of justice and democratic projects. I think for most of you who are working on AI products, the employment workers management and access to self-employment tools and specifically the education vocation training may be relevant, 3 and 4. Maybe also 5 for the financial sector. Who is looking at this and thinking, oh, I'm working on a high risk AI system? No, that's what we say. Talking again about the obligations, they need to establish a risk management and then a data governance framework like accurate data, quality data, etc. You need to have technical documentation on how your AI system works, restrictions of use. You need to inform the employer thereof, how they need to deploy it in line with the purposes and the intended use. There are record keeping obligations to have logs in relation to your AI system. You can oversight. You need to also look at the accuracy, robustness, and cybersecurity of your AI. All of these, they have either model documents that you do, or they have the European Commission used to come out with more additional guidance or forms you can fill in with some of these requirements. So nothing is really 100% actually a lot of development and discussion going on around how this needs to be practiced. But it's good to know. I'm happy you can be knowing that there are some policies that you might need to look at if you're working with AI.
Another question about private data. So I think a previous slide you mentioned access to private information or kind of
Private services.
private services. Yeah. So I'm usually working on building agents that control someone's computer. And while manipulating the computer, they can encounter like their insurance information, but so does that count as access to private data?
No, it's like access to services, like private services, like access to life insurance. access to a bank loan, access to financial services. So if that would be impeded or cited by an AI, that would be classified as high risk. So not access to the data, to the information, but really as a person having access to service.
Good.
So one of the key aspects of AI Act is you need to have transparency around the use of AI and the use of AI systems, also in particular about Gen AI. But do you think all of us can understand that we need to have a disclosure whenever we're dealing with deep fakes and chatbots? There's an output marking requirement so that it's, you can easily see that something is AI generated. LinkedIn's already working with those AI labels that you can add to your post, but this needs to be also machine readable format when you create synthetic content. And users, for example, in context of chatbots, need to be aware and informed of the fact that they're interacting with a chatbot and not an actual person. Going back to the GDPR and the AI Act, there are similarities, there are overlaps. Like the GDPR requires companies to have a data protection impact assessment, meaning if it's a high-risk process, you need to look at what could be the impact to the freedom and the privacy protection of individuals. How can you mitigate that impact? What could be potential risks and harms, and how can we mitigate that? That's already a requirement in the GDPR. The AI Act also requires you to undertake a fundamental risk impact assessment. So it's a bit more elaborate than the CCIA under the GDPR, but it could be used for the same purpose, that framework. Standard management system. Except for the AI Act, the scope is a bit bigger because the harms could be more than just the harms to personal data. There's also a post-market monitoring requirement. Not going into detail about that, but just call it out. GDPR also has a fair and lawful processing requirement of personal data. Same principles apply that you need to have extensive data governance, including the use of appropriate data sets with high quality that are fair and lawful. Accountability is a big item under the GDPR, same for the AI Act. And then the requirement to maintain records of processing activities under the GDPR. So you need to have an overview. Every company needs to have an overview of the data that they process and how it's processed, who it's shared with, et cetera. So you need to have insight into that data. And the AI Act requires record keeping on event level. So there's a separate section for general purpose AI models. Those are AI models that are meant to do a variety of tasks and not just for one simple application. There are certain obligations. There is also an obligation to drop technical documentation for the supervisory authorities and to inform the people using your GPAI model on how they can do that, in compliance with the AI Act. You need to provide technical documentation, same as you would for product safety purposes, right? We always get these big booklets with every product that we buy with information. You should think about that in the context of AI. The European Commission published its form that you could use to provide that information. If you're interested in that, you can look at this link, go through the form, see what type of information is required. You need to also, as part of that, need to publish a summary of the content used for the training. I'll have to say, this is not just an EU requirement. There's also laws in the US that require a summary of the training data used for your AI. So again, I know most of you are probably US oriented, but just wanted to make the point. It's really not just the EU. And then there's also a separate category for systemic risks that are associated with the AI models. Those really just apply to like the big ChatGPT models and the like. Just to drive the point home that it's not an EU thing, I've also looked at the Colorado AI Act. Nothing you need to know by heart, but the Colorado AI Act is similar to the EU one. It's effective February 1, 2026. It's for developers, employers doing business in Colorado. Arguably, the US is a more difficult market to work at or to do business in because
their landscape is fragmented. All states have their own AI Act. All states have their own privacy laws. They have sectoral laws. So to navigate that framework is arguably more complicated than navigating the EU. What the US does have in its favor is Trump, who's in favor of pro-innovation and not hampering innovation through AI regulations, et cetera, et cetera. So most likely the enforcement priority will not be AI for the FDA, but that could change with a different administration, a different president. I mean, it's never very clear what you're dealing with when you're in the US in terms of predictability. And then for US laws, it's more common to have like a fine per resident that is affected, as opposed to the EU where there's like one lump sum that you can be fined for. Same with the EU. The Colorado's AI Act is focused on high-risk systems. It has an exemption for the narrow procedural tests that we also talked about in the context of the AI Act. And it requires you to have, to apply reasonable care to avoid algorithmic discrimination. So the overall framework or the basic principles under the Colorado AI Act are similar. I have an overview here of how they compare in terms of main requirements, but you can see while there are some specific differences, they both have documentation requirements, instructions for deployers that they need to give, and risk management obligations. What's interesting, though, is that there's not always an overlap between what is considered high risk in the EU versus what is considered high risk in Colorado. And there is some overlap, but they don't have an overlap where it's, healthcare services, housing, insurance, legal services. Colorado feels like that is high risk. But they don't think biometrics, emotion recognition, et cetera, central private services are high risk, but the EU does. So that's where there's some deviation and some overlap. So that's something that companies should learn to navigate. And I'm just closing it off with an overview of considerations that you need to take into account when you're working with AI systems. Think about web scraping, training data. You need to usually have terms of use, acceptable use policies of your AI systems, the technical documentation, privacy, security, compliance, how you're going to think about the use of input data, the use of output data, especially if your customers require you not to use their input and output data for the training of your model, fair use AI policy. Just a couple of things to stir your thoughts, and I'm going to leave it here and open the floor for questions and answers or discussion.
Great. Thank you very much. We're going to have a small chat and everything. If you, let's start with the first question that I have. And then everyone who wants to ask questions will have an opportunity to ask anything you want. But yeah, please have a seat, Marta. We're going to have, and we'll get the water as well. But that was an interesting thing to learn. And I want to start with the really simple question. So let's imagine that I'm the small startup that I'm starting the business and I'm trying to have customers in EU or let's say in EU. What is the cost to get myself as a startup to be GDPR compliant? Like the cheapest way to get this thing done?
Good question. Depends on the type. Depends on the type of product that you have. Like some are very data driven, like high data value. Others just barely touch upon data and like they can get by very fast. Also depends on if you're considered the controller of the data or if you're just a service provider. Like, are you working for a customer? Or are you just doing what they want you to do, developing a software, providing a service? Or are you actually collecting individuals' data for your own purposes to train your model or to create your, just to sell your service to the individuals directly? Those all depend. What I do want to say, and I had a discussion today with someone in attendance, It's not as difficult as it seems. Like GDPR doesn't say you can't process personal data. It doesn't say, you know, we don't want you to do anything with data. It just tells you to think about, do I have a loss of basis? Do I really need this data for the purposes that I want to collect it for? So let's be honest, if you have a registration form with like your whole life, like your name, address, birth date, what do they need it for? Oftentimes they don't even need it, but they will ask for your date of birth out of habit. And so just GDPR just requires you to think about that. Do I really need this information for my purposes? And it requires you to clean up your data. Like, why would you have data that's 20 years old? I've talked to many companies who still have that. I've had companies have a data breach with 30-year-old data, and they've had to go back to these people 30 years ago to tell them, oh, I lost your information. It's just embarrassing. So the costs differ. You can do a lot yourself. I would say, like for a startup, I think you can get by with 5,000.
5,000, 5K?
5K, yes. If it's a simple processing activities, not too complicated, not high risk AI system.
And what is that? It's the cost for a lawyer to get all the paperwork, or what is that?
Yeah, it would be cost for policies, procedures, information on, what I usually do is I do a data flow mapping with companies. So I need companies first to think about what data do I have? Do a data flow mapping. Where does the data come from? Whose data is it? What do I do with it? Who do I share it with? Where do I have it? Like, what are my systems? What are my IT systems? What are my cloud service providers? Have an overview. On the basis thereof, we look at, is all the data that I'm collecting, do I need to have that data? Do I have a legal basis? Do I have the contracts in place? Because there's also a contractual obligation there to have with your service providers if you share the information. So, I mean, there are a couple of requirements, but nothing undoable or that prevents you producing.
Okay, I want to have some debates, like AI world and legal world, let's say. So what if I go to ChatGPT and say, make my company GDPR compliant, prepare me all documents, ask me any questions, and then I save, let's say, 5K and get all the documents from ChatGPT with like everything filled in for my company. What do you think? Would it work? Like anything against that, or any risk you see in that?
You could do a lot. I mean, I would love for people to have a good privacy policy on the basis of ChatGPT. I wouldn't be opposed to that. I do think like ChatGPT can't tell you what your role is. It can't tell you what you do, what your lawful basis is for processing personal data. You would have to ask the right questions to ChatGPT to understand whether you're complying with your obligations. For documents generation, yes. For understanding your obligations, maybe no.
Okay. Do you have any questions so far, guys? Ask anything, just raise your hand and we'll go to the questions. So what I feel, and maybe we have two questions. Okay. What I feel, and maybe you can prove it or not, that it looks like GDPR it's kind of over-regulating, and I think we had some comments here as well. Don't you think that it doesn't support the development of technologies, and maybe it prevents from like a faster growing than it's in the US, for example? The simple question is, don't you think that it's over regulating everything?
Honest answer, not because I'm a lawyer, but no, I don't think it's overregulated. I think there is a perspective that it's overregulated. So it has a bad rep. Let me put it that way. GDPR has a bad rep. But I haven't, like in my 10 years of working with companies, including global companies, I haven't come across like a use case of data that they couldn't do because of GDPR. It just requires you to have like a maturity to think about how you approach it. Overregulation does play a part, I will admit that, in the context of marketing, like the opt-ins for newsletters. People hate that they need to have that. Cookie consent. I mean, okay, we also don't want to always give consent to cookies. But I mean, overall innovation, developments, does that hamper that? I don't think so.
Okay. Let's have the question from audience and then I'll come back to my question.
Thank you, Marta. I appreciate it. It was really, really informative. I believe that's what we're all struggling with right now, to figure out like, are we ready for AI and what's gonna be the consequences? Maybe some of us are like really super excited about it, but I know there are like a lot of people and organizations and maybe the countries that stand behind that and we're like getting a lot of concerns. Because after that, we're gonna have a lot of legal issues that I believe that's where your job is coming from. It's a lot of job. So my first question, there are two questions, but the first, and I would believe that would be the main one. And it was in your slide when you were saying about accountability, when you're saying nowadays AI, I believe it's a lot of ethics and what you've mentioned and what we're talking about today, where you say act, it's about AI ethics. All the things that you have mentioned on your slide is also like super correct. And it's all about ethics. So how do you think the firms and like one of your like law firm and again I said like bigger organizations are ready for that ethical accountability because it's like sort of accountability is like a lot, it's like a lot of responsibility, but that it's a lot of ethics. Like how can you be accountable for the ethics of the person, then of the team and the management, and then goes on organization. Thank you so much. Yeah, that's a good question. I think so. The AI Act has all these technical documentation requirements, risk assessment requirements, fundamental rights impact assessment requirements, all of that just to make sure that, people think about what they're doing with AI. And so the law tries to cover that by having all these requirements, documentation requirements, policies, procedures, etc., so that they're forced to think about the negative consequences that their AI product can have. They never say ethics or ethical AI or responsible. It's always about think about risks, think about risk mitigation measures throughout the whole life cycle of your AI system. And to be fair, it's not it's a good thing to ask, right? We always need to think about risk. And the risk includes risks to fundamental rights, where sometimes, it's adjacent to ethics. My concern is how do we make the people want to do the right thing? Because the issue is usually, okay, but what if we don't do that risk assessment? What's the harm? Or are we going to be enforced? Are we even, are they even going to know we have this product, or who's going to find out, right? I think the challenge is more, how are we going to make sure that people want to be doing the right thing, rather than does the law have the right to it? Because I think the law like makes you think about that, but are you actually going to do that?
We had another question, right? Who had the question there? Yeah, we have.
Thank you very much for the talk. I have, I think, a threefold question involving, I think, different aspects that you had in the slides. One thing is enforceability. Essentially, how much can you verifiably enforce GDPR, the AI Act? The other is detectability. Essentially, you say, yeah, AI should not contain biases, should not have latent assumptions about the world, but even within research, we don't have any tools to explicitly detect that. So how can we enforce it? And the third one is, I guess, more like about risk management. We don't explicitly have any risk management like protocols, like CVEs, like other software, I guess. So what does that leave to the law part of the whole conundrum?
Okay, let's start with enforcement, and how you can confirm that. Okay, GDPR enforcement, I will say this, is very complaints driven. So either you're like ChatGPT and you become really big and the regulators are concerned and they look into your product, or enough people use it and enough people complain about it that the regulators pay attention. They're understaffed, so there will definitely be prioritizing what do we enforce, what do we look at. Under the AI Act, and this also goes to accountability, you're required to, like, the burden of proof is on the companies to show that they've taken a look at risks, they've taken a look at mitigation measures, but also that they've tested it. So a lot goes back to testing your product, like trying it out, seeing if it comes up with output that is not desirable, with collecting feedback, that type of thing. The post monitoring requirements are really meant to cater for that enforcement aspect of how to make sure that it doesn't contain any biases, etc. Your third question, sorry, I already forgot it.
Yeah, I said like even as researchers, we don't have explicit frameworks or ways to assess risk, assess biases. Like we even see that in many researches that AIs actually have like that biased latent reasoning in some social or racial bias perspective, but they're so hidden that you can't explicitly test for them unless you like seclude it explicitly very hard, which is not always the case. You can't really always do it.
Yeah, I get that. And I will also say that this area of law is so in, how do you say that, in development. So the AI Act creates a framework, but then it leaves up to the European Commission to create codes of practice, to create standardizations. It has a lot of requirements, such as, the Commission will speak to stakeholders and other like expert groups to create ways to monitor, etc. Like my point is, we have the framework, but the actual execution thereof is still open to creating codes of practice, is open to developments, because the developments also go really fast in terms of what you can and cannot do. So it does leave room for that in the act. And also lots of stakeholder conversations, discussions. They have an expert group as well that they need to appoint that will help them with that. So it's really in flux. The law tries to catch up with the innovation, but it also tries to have a law that is innovation neutral.
Just to probably add to that question, I'm curious to know how the process of having penalties work. Like first of all, how often is that happening if you have the data? And like, if I'm the small company startup, do I really need to care about? Because it looks like GDPR, all these authorities, they are focused on the bigger companies like Google or others. Do you have any like?
No, I do have insights into that. There's even a website, enforcementtracker.com. There are many GDPR fines, and there are also many smaller fines. It depends on the regulator. It like really depends on which jurisdiction. Sorry, I'm like not looking at this side of the group. It also depends on which jurisdiction. Some regulators love small fines, like the Romanian, the Spanish. Like they will fine everyone and then give them 5,000, 10,000, 30,000 euro fine. The Irish Data Protection Authority, because most big tech companies are headquartered in Ireland, they are tasked with the enforcement of the big tech companies. So the Irish one, they will come and use. They're so burdened with the big tech companies that they don't look at the smaller ones. So they're finding Meta, they're finding Apple, they're finding whatever big tech companies there. The Netherlands is more conservative. So my point is, every jurisdiction has their own sort of culture of fining, their own practices of fining. There are regulations around what the amount of the fine could be or should be, and the mitigating measures that can make it lower, or any issues that can make it higher, the fine than the base fine. But yeah, like I said, it's complaints driven. A lot of it is complaints driven. So if you're doing anything to annoy people or to scare them, they will complain and there will be an investigation. If you're an open AI and you're just launching and everyone's looking, wow, we have a ChatGPT, what is this? The regulators will think about it. Actually, when OpenAI just published ChatGPT, the Italian regulator blocked it. They were like, we don't understand what's going on. You can't use this in Italy. Yeah, I see everyone's looking like, but yeah, it was prohibited in Italy for a while until they put in place appropriate age verification mechanisms. The investigation is still ongoing in Italy, but they've allowed it to be back online for people after they put in place the age verification mechanism.
But the Italian authority can't block it for the whole EU, only for
Italy.
Okay. We have another question here.
I want to thank you and organizers of the event and also creators for this place. Yeah. And my thought about that, I think now we will have a situation where we could create new AI regulation laws using AI. It
Okay.
can be possible. Yeah.
Okay.
And I think that to follow their guidance, we will need at some point, like for one token generated, we will need maybe 10 tokens to follow the rules. Maybe it also like my goal. And my question about that is, do we have some regulations in like law space, like AI regulation in law?
Specifically for law,
Yeah.
no, the AI Act is very, so the way the EU tries to make laws is to make them technology neutral. So the GDPR is very technology neutral. It can apply to blockchains, it can apply to AI, it could apply to like regular cloud processing of data. And the same is for the AI Act. What's funny is when they were negotiating the AI Act, there was no ChatGPT yet. And then when ChatGPT was published, they were like, wait, we need something about general purpose AI models. And then they added that general purpose AI model piece to add to the requirement. And so also for the AI Act, they tried to make it technology and sector neutral. So I don't think you'll ever see an AI Act specifically for law.
Okay, cool.
But they could add law applications to the high risk assessment category. Thing is that the high risk, what is considered high risk, can be changed by the commission.
Something.
I want to come back to the first question that I asked about the GDPR compliance. Is there any certificate that you need to get then to show to your customer? How you prove that you are GDPR compliant?
So there is a possibility for GDPR certification, but the certification bodies have not formally been approved yet. So if there's any party saying, oh, I can give a GDPR certification, it's not like the formal it's former certification under the GDPR. It'll just be a marketing thing, which could work. I mean, I'm not saying no. I mean, I could also look at your GDPR with compliance and say, yeah, you're compliant, and you tell your client, well, my lawyer looked at it. So two things. One is your accountability requirements towards the regulator. So how can you prove it? If the regulator asks, you need to just show documentation to show that you've thought about it and you have what you need to have. Other thing is in relation to your customers. If you're a service provider and you're doing data processing for your customer in the EU, they have audit rights in the contract. So they're allowed to look at your processing activities to see if they think anything was off. Not everyone uses it, but they could. Second thing is, again, the general accountability requirements. If let's say if there's a data breach, your customers are going to ask what happens. And then you need to explain them, oh, I didn't do this patching or security patch, I didn't apply it. And then you're going to be on the hook for damages from your customer, potentially regulator fines, potentially litigation from individuals, because they also can, litigate these mass claims for data protection and non-compliance.
Okay, great. I have some hands or questions. Yeah, we have. While I'm going, will we have an opportunity to receive the presentation that you had? Are you okay to share it with the audience?
Yeah, if anyone who wants the presentation sends me an email, I'll send it back.
Okay.
Well, thank you for presentation. Very insightful. So my question is the following. So I have explored a little the AI Act. I have spoke and I had many conversations with my friends who are leading risk in large European banks, etc. And looks like a lot of stuff has been done having in mind some kind of single responsibility models, like you are scoring the applicant for hiring and so on, right? But the progress going in the direction that you have one very horizontal reasoning model, which has the ability to create a plan, use tools, use context and do a lot of actions. So how all these regulations are going to keep up with that, with pure agentic play, where you just give an instruction and model choose the way how to implement that. And the second question, do you see at some point just the AI system will be regulated the same way that people are? So what is permitted to the person is permitted to the AI system as well, and vice versa.
It's a good question. I mean, I said it's technology neutral, so theoretically could also apply to agentic applications of AI. There are some requirements in relation to the chain of AI use. It's, I mean, if we look at a specific use case, we could, look at the AI Act and the use case. I'm pretty sure we can find a way that it's applicable also to the agentic AI applications. That's also why some provisions in the AI Act, they talk about the operation of the AI system needs to have A, B, and C. They don't say the deployer needs to do this or the provider needs to do that or the distributor, but they say the operation of AI so that like they can say, oh, whatever applies here, we think anyone should comply with these requirements. So you can see that the law is also struggling with that. And they're trying to say like so very high level anyways, we want all AI systems to comply with these requirements. We don't care who does it.
Great. Okay. Any other questions? No? Okay, great. Thank you very much, Marta. I think that was very helpful.
Welcome.
And if you can leave, do we have your contact information there?
Like,
Okay. I think we'll share it in the email after the who was registered to the event. So we'll send the contact information in the email. Thank you very much.
Thank
It
you
was
for having
a
me.
big pleasure to have you. Yeah, thanks.